Well, hello and welcome everyone to another episode of the Bill of Rights Institute's 10th period webinars. I am Kirk Higgins. I'm the Senior Manager of Education here at the Bill of Rights Institute. And I'm joined again by my colleague, Rachel Davison Humphries.
Hi, everyone. I'm Rachel Davison Humphries, Director of Outreach here at the Bill of Rights Institute. And we have two fantastic guests today. Kirk, who's with us?
This week we were joined by Dr. Joyce Malcolm at the Antonin Scalia School of Law, and Jotwan Daniels, who is one of our Bill of Rights Institute teachers. So, and after some brief technical difficulties, we're excited to see you.
We're all here.
So
good to see everyone.
Yeah, so nice to see you.
So I wanted to start out our conversation today with a bit of a fun question for Jotwan and Rachel. And that is, what is it that you two think about semicolons?
Okay, so I have to admit, I knew this was coming, Jotwan, so I'll go first to give you a second to gather your thoughts on the robustness of the semicolon.
Well, thank you very much, Rachel.
You're welcome. You guys came into my office earlier today. You're like, Rachel, what do you think about semicolons? And I was like, we're nerds. And then I said, I think that semicolons serve a particular use in written language that doesn't exist in spoken language. So I feel like semicolons serve a function for preparing the reader to understand something that's happening later on in the sentence. So it's like it's a visual cue more than a punctuation mark like we use in daily speech, right? And so I think that like a lot of times I know students struggle with semicolons because they're not intuitive because they're a function of written language that I think isn't even common anymore. We don't use written language the same way that we used to. We tend to write like we speak. And it used to be the case, especially in the 17th and 18th centuries, that we didn't write like we spoke. We wrote in this very particular way. So that's my thought on semicolons. Jotwan, what do you think?
I think I am going to piggyback off of your very well prepared response. And I do think that it does make a little bit more sense visually than it does in terms of the spoken language. Typically, when I focus on semicolons in the classroom setting, I explain to kids that semicolons mean that there is the story that will be continued in a different thought, perhaps in another space within that reading, as opposed to just continuing to join all of these connections together at once. Let's just pause and think on this for a moment to be visited later on.
Great. So I think that's excellent. And if anyone in our audience has anything else that they want to add on this, please feel free to leave a comment on YouTube, or feel free to send us a comment on Twitter or Facebook. Twitter, it's BR Institute. And on Facebook, it's facebook.com/Bill of Rights Institute. And I love that you both pointed to written language because, as it turns out, our topic today is Marbury v. Madison. And it just so happens that that case has to do with interpreting some written language. And so, Dr. Malcolm, I wonder if you could tell us from a legal perspective, is the semicolon pretty significant? Because from my reading of this case, it seems like it's fairly significant.
It is. It's usually in written language, and certainly from legal cases, separates a whole series of things that are about to come, which is basically what you were talking about, but often in the same sentence. And I should say, in the case that we're going to be talking about today, Marbury versus Madison, John Marshall, who wrote the opinion, wrote a long, long opinion, over 9,000 words. So I'm sure that he had plenty of semicolons in it. And basically, we need to, and particularly teachers and all of us, need to get to the heart of what he was trying to say, despite the great length that he went to explain his reasoning.
So I think that's great. So maybe by way of just kicking us off, Dr. Malcolm, could you just give us sort of an overview of what Marbury versus Madison was, how the case came about, and what Marshall's decision was?
It's an interesting background because John Adams, who was then president, was ending his term shortly And the members of the other party, President Jefferson with Madison, who would be his Secretary of State, were about to take over. It's amazing how quickly the founders divided into, pretty, I wouldn't say vicious, but strenuous opposition. At any rate, Adams issued a whole lot of nominations shortly before his term was to end for all kinds of judges, including, I should say, Marshall, who he was appointing to the Supreme Court. And what happened was that this was just within days of the end of his term. He had all of these commissions that had been approved for judges. And Marshall, in fact, himself, who was in Adams's administration, was busy handing them out, sending them out to people. And at the very end, when Jefferson takes over, there are still a few that haven't been delivered. And one of those belongs to Marbury, who had been appointed a lower court judge, but because his commission was not delivered in time before the new administration claimed that he should not get that particular position. So that's basically what it's about. He appeals to the Supreme Court, who, in fact, the man who didn't get him his commission is now the Chief Justice, John Marshall, to get some justice for the fact that the president had approved this nomination, but because it wasn't delivered, they don't want to give it to him. So that's basically what the case is about.
So the case comes before the court, and I think it's one of the first, I guess, significant cases that the court hears, and ultimately the decision comes down that John Marshall, so people say, establishes this idea of judicial review. Where does that idea come from, I guess? As we all know, it's not something found in Article 3 of the Constitution, but is it something that Marshall pulls out of thin air, or is there some precedent for it?
Did you want me to address that?
Yeah, please. Sorry.
Okay. Actually, it is not in the Constitution. In fact, Madison, who was the father of the Constitution, didn't really like the idea that the judges were going to have the final word. And he felt that his first idea was that Congress would decide whether the legislation from every state was constitutional or not. And clearly that would give Congress no time to do anything else. That didn't fly. Then he had the idea that there would be a council that would have the president on it and maybe a couple of the judges and some congressmen, and they would decide. But the founders and the framers of the Constitution didn't like that either. So judicial review has a slight English background because one of the great gurus of English law, Sir Edward Coke, had decided in an early 17th century case that if Parliament passed a statute that was unreasonable and difficult and violated common law, that it was null and void. And that idea was really important to Americans, that if the legislature should pass something that didn't make sense or violated the basic laws, that the court could decide it was null and void. I should say the English poo-poo that whole idea, and anything that Parliament did was fine. But the Americans took that notion that the court should have the final say. And this case is Marshall making that claim. And of course, it's had a tremendous history, but we're rather unique in the power that our Supreme Court has. The founders never intended it to be as powerful as it has become because of this role it's taken on.
So
go ahead.
Jotwan, how do your students, how are they introduced to this idea? What's the context in which you work through the Marbury case?
I kind of sort of, when teaching this lesson in the past, I kind of sort of dealt with like the legal problem in terms of, an essential question would be, could one branch of the government, that branch being the U.S. Supreme Court, could the Supreme Court order another branch of government, the president in this case, to do something, and who would have the final say? And usually with some sort of essential question like that, it kind of makes it a little bit more relevant and what's the word I'm looking for? Attainable for students to deal with these constitutional concepts. From there, we kind of sort of do get a little bit lost in the story because kids are kind of confused. They're like, wait a minute, was this guy, who's making the decision? Is he the Supreme Court justice? Wait a minute, wasn't he the Secretary of State? What's going on here? But ultimately, what we try to focus most of our attention on is the establishment of the use of precedents in order to establish a very important role of the court, and that is that notion of judicial review. And so I kind of sort of shorthand it a little bit and say that while Jefferson technically won that battle, the Supreme Court ultimately won the war as it became the arbiter to define the most distinct separation of powers. This is a power that the court continues to hold to this day. And from us basically discussing what occurred back in the 19th century, I'm able to bring in more modern cases that reflect on this concept of judicial review and a very important role of the court that was never quite spelled out in the Constitution itself.
Yeah, I think that's great because it is, as Dr. Malcolm just mentioned, something that has ramifications. But I also think it's interesting that judicial review, didn't just take off. It's not as though, all of a sudden we had, the Supreme Court deciding constitutional case after constitutional case. Is that accurate to say? I mean, that sort of that changing of the court's role took some time?
Yeah, the court really wasn't that important in the first years. And John Jay was the first Chief Justice. So it's Marshall really who, through these decisions, puts the court kind of at the center. What he's saying is you have a constitution, either the Constitution as the supreme law of the land or an ordinary statute trumps the Constitution. And so you have to make that decision. And if we're dealing with a written Constitution, it has to be the Constitution that is the prime decider. And then it's the court that should decide what the Constitution is saying. And that's where we get into, your question about, well, who else could do it? If it isn't the justices. In a place like Britain, they feel that the political branches should make that decision. So as Parliament makes the decisions, they have a Bill of Rights, but it isn't the courts that have the final say. It's usually Parliament. We have given that to unelected judges. So they're not accountable in the way that our political branches are.
Right.
But they have that role in this country, and it's almost unique, really.
Yeah, I think that's really interesting. And again, it brings us back to ours being a written constitution. And I know that that's something that Hamilton referenced in Federalist 78, when he talks about, which many, I think, see as sort of tipping that judicial review was something that was understood to be a power that the Supreme Court had. And I wonder too, because Jotwan, I think that idea of things being written down is something that our students can oftentimes take for granted, or that the fact that we have a written constitution is something that, while not unique, I think was unique for the time. How is it that you get your students to think through sort of the rule of law and how it, is practically plays out?
Glad you actually asked that question. I tend to teach U.S. history slightly different every year. And with this school year, we started off with an inquiry-based lesson in terms of how democratic is the U.S. Constitution. And we focus very, very, very intently on the specific language of the document. Kind of sort of got to the concept, at least from the kids' point of view, that in its original inception, our republic really wasn't as democratic as we would think it is today, but rather it's the process of amendments and the living Constitution being able to be changed as the times go on that allows it to be considered this democratic document that we hold in awe today. But we do get into a lot of that very specific language, which I do believe is a big issue within the case Marbury v. Madison. Can the court take on a role that it was not specifically given if we are going to be a nation based on the rule of law? If we are going to be a nation that holds a written constitution, could the court actually make that power play and take this power if it wasn't written explicitly in the document?
Yeah,
obviously.
Please. No, please go ahead, Dr. Malcolm.
Obviously, they did take that power. I mean, Marshall did. And it took a while for, as you say, that concept to be appreciated. I mean, because you also have states with state laws, and judges who did what Marshall did were sometimes impeached in states. So the notion that the Constitution is the supreme law of the land, I think, was really important. Just want to say I have my little Constitution here, and it's and all your students should have a copy. But the thing I love about it is it's so, and I have all my students have a copy. It is so short. It is one of the shortest constitutions of any. Modern constitutions are so long, and it basically has these basic principles. But as you say, they need to be understood in changing environments. But it is the law of the land, and nothing is more important than the rule of law, because we've seen countries that completely collapse when there's no rule of law, when the government is corrupt, or when there's just chaos. So we're really very fortunate. We might not always like the laws that we've got, but it's really important that we obey them, or at least respect them, because that's what keeps this country, steady.
A little short plug for the Bill of Rights Institute. If you need pocket constitutions for your class, the Bill of Rights Institute does provide free class sets of pocket constitutions. So if you
excellent.
So if
I've got thousands.
If you go to Google or search engine of your choice, Bill of Rights Institute pocket constitutions, you'll be able to fill out a form to get a class set. We sometimes are on a bit of a backlog, which is a good problem to have. So please be patient. But we do have those, and we give those away to everyone. I find this, and Kirk, we can go a different direction, but I find it kind of poetic that it was the justice branch that recognized the need for the check of the justice branch. That it wasn't laid out in the Constitution that this would be a responsibility, but it was through our legal institutions that this responsibility evolved. Would you say that that's a way to think about it?
If I can throw my 2 cents in, I mean, I think that's really interesting. And I also think it's interesting that the way Marshall shapes the case is that he's focusing it on the rule of law. He's not focusing it on the judiciary itself, but instead saying that this document is ultimately, the thing that we all need to appeal to. And so I think establishing that, to me, injects the stability that Dr. Malcolm was just talking about, which is to say this neutral document, open to interpretation, obviously, is the thing that is supreme, and everything that routes through our legislature and everything else now goes through that. And by the way, because of where the judiciary is positioned and what its function is, it's in a good position to sort of read and interpret that document.
Yeah, and I think people accept that. Actually, unlike other countries, the members of our Supreme Court are like rock stars, actually. People know who they are, which isn't true of other countries. And we're one of the few where they
Has that always been true in the United States? Has it always been the case that the Supreme Court justices have a kind of popular knowledge of who they are? It feels very present right now, which I think is a feature of a number of different things like television and technology. But has it been the case that the justices have this kind of elevated status?
I really doubt that they were quite as well known. And there were presidents like Jackson who just thumbed their noses at the Supreme Court, really, and even Lincoln, with withholding habeas corpus in Maryland at the beginning of the Civil War, kind of ignored the Supreme Court when they made their decision on it. But I think that now the Supreme Court seems to be taking a greater and greater role. A lot of things maybe that would have been sorted out in the legislature are now decided in the courts. So, I mean, I sometimes say that it's the Supreme Court that decides when we can be born and when we can die and everything in between. And maybe that's good and maybe it's not so good, because you're giving these 9 people a tremendous amount of power over all kinds of aspects of the lives of the people in this country.
So I want to.
Can I chime in right now off of that point?
Yeah, go ahead, Jotwan. Go right ahead.
I'm sorry, guys. Dr. Malcolm, I appreciate that point too, because that's something whenever teaching the judicial branch, in specific these key Supreme Court cases, within the classroom setting, I try to make it an absolute emphasis that we are dealing with individuals, humans, who are making key decisions that are going to impact the lives of individuals, not just in the moment that they are making that decision, but also in the moments that are going to follow that key choice. So I think it is very important to emphasize that not only do these individuals have power, but the power that these individuals holds impacts real individuals, real families, real lives.
Yes, it does. And we've made that decision. I mean, other countries don't necessarily trust, appointed judges to do that. I mean, and that maybe it's because we're so much reliant on a written constitution. But and sometimes you feel, well, are these people really the ones to be deciding those things? And it's very hard to go to another constitution. And our Constitution, it's very hard to amend the Constitution. It's extremely hard. And so if it were easier, presumably if you didn't like a Supreme Court decision, you could make some change in the Constitution. In our case, that's very difficult to do. It maybe saves us from, the kind of tyranny that other countries have, because their constitutions can allow the president to, people can change it easily and they serve forever. But it's a trade-off, that we trust these people, and they obviously are human beings, as you say, who have their own views of things and live in the society too. There's one of my colleagues that thought that the Supreme Court members should go back to riding circuit. They used to travel around the country and hold court wherever they went. And he felt that if they did that again, they would have a better sense of the impact of the things that they were deciding, because they would be out there experiencing them.
So we have a question coming in from YouTube. Vince from YouTube said, and Jotwan, this speaks to you. How did the Marbury v. Madison ruling set the stage or not set the stage for the Supreme Court to be involved in political situations going forward? So this was a very political thing with Adams and Madison.
Oh, yes.
So how did that set the stage for the kind of politicization of the court? Did it or didn't it?
I'd argue the very next case that I get into from this one is Plessy v. Ferguson, and then Brown v. Board of Education, in terms of that whole notion of separate but equal, and how that law gets challenged in Plessy v. Ferguson, but the Supreme Court in 1896 says that separate but equal is perfectly constitutional. Or for instance, when we get into Brown v. Board of Education, maybe even more current cases such as Bush v. Gore, in terms of the impact that this is going to have. But the next lesson that I usually get into is that notion of separate but equal, and the role that the court makes that is going to last in this country for quite some time.
And then the role of and that's something that whenever I was with students, the idea of overturning, that the court makes bad decisions, that it recognizes.
Yep.
And that's a feature, not a bug, right? It was a design element that the court would then be able to overturn itself. Right, Dr. Malcolm?
It can, but the judges are very reluctant to do that. That's called stare decisis, sort of looking to the past to build on. So they're very reluctant to overturn something that's very long-standing. But happily, they do. And they have made mistakes. They're human beings, and they're also products of their time. And I think that makes a difference. For a long time, I guess in the separate but equal case, and the integrating the schools, the court began to accept political science studies and other kinds of information that it hadn't before, and that was quite novel. So I think that they do change and often correct, or at least find some way of sidestepping a case that has been wrongly decided. I mean, one of the worst decisions was in the early in the wake of the Civil War, the 14th Amendment which was meant to make sure that everybody in the states got all of the rights that they were entitled to. And yet the first case that came up about that, called the Slaughterhouse case, made a distinction between people that were citizens of a state and citizens of the country, and basically thwarted the intent of that amendment. But the court got around it by using other aspects of it, of equal protection under the law and due process, to give people in the states the rights that that amendment had initially meant to do. But they still, they haven't officially corrected that. Justice Thomas wanted them to in a recent case, but they were reluctant to correct that mistake, and they had gotten so used to finding ways of getting around it that they kind of stuck to that. So sometimes they will completely change things, like in the Separate but Equal Plessy versus Ferguson, and other times they just try and find some go around to do the right thing in a case.
Yeah, and I think that idea of the justices being human is really interesting, and it's something, you know, I know that we like to focus on too, is not just the majority opinions, but also the dissenting opinions. I know, for example, Justice Harlan's famous dissent in Plessy is one that shows, look, these are arguments, these are debates, and I think that that's a good way too to invite students into that conversation. I mean, there's typically in these cases, there's very smart attorneys on both sides that are making very eloquent arguments. And so taking both of those seriously and looking at the case and having the students think through it, I think is a powerful way of engagement. And, you know, it also, talking about sort of the politicization of the court made me think of something that I always think is extraordinary. And I think Marbury is a great exemplar of this, which is people typically, Jackson being a great exception, and Lincoln's pushback against Roger Taney being another, but people typically take the court as the arbiter of these things. And so Rachel mentioned sort of the election of 1800. It's a very tumultuous time, the first time in American history where we've changed from one party in power to another political party in power. I mean, it's a time that is fraught with disagreements and negativity. Some people might be nodding their heads and saying things sound similar in the present day. But the idea that the court is there as this sort of neutral arbiter seems to be something that has been established in the United States. And it makes me think of Bush v. Gore, which I think you mentioned, you know, that Bush v. Gore decision comes down and that's it. You know, it is the decision. And I wonder, Dr. Malcolm, how much or what you think about that. I mean, is it something that is just that we just revere the court out of a tradition? Is it because we have this stare decisis precedent, you know, that we're reluctant to make these changes quickly? What do you think kind of gets us that respect for the court?
I think the court is very aware too of relying a lot on popular respect. And so they're really careful, I think, not to do something that will really upset a lot of people. I think with the Bush v. Gore, they were really anxious that that would lose them a lot of respect from people, that they shouldn't have gotten involved in that. So there is that issue of respect, because so much of, I mean, the times when the court was thwarted by former presidents was challenging their authority, really challenging the respect that they ought to have had. And so I think that they may be changing things slowly, looking to the past, trying to build on these issues is their way of being sure that they are still held in respect. Because if the court really went off the rails, I think that would, you know, be a real loss. But as you said, they have that continuity. They serve for life, and once they're on there, unless they do something horrible, they're there. I teach a course called Comparative Constitutional Law, and it looks at civil law systems in Europe and other places, and some other common law systems. Ours is the only Supreme Court where the judges sit for life without any term or age limit. So sick judges sit. Any judge who wants to stay on, stays on. You know, we don't have any limit. And there is that continuity, and that in some ways is really important.
And I think that goes to Elliot from YouTube had a question or comment on the Supreme Court's intervention into kind of political questions because of fears about the politicization of the court.
Yes.
Of the court.
Of the court itself. And so I hear you, Dr. Malcolm, saying that the court's very self-aware of their status within culture and making sure that, or they take action to mitigate any sense of politicization. How would you say that they do that? And then what's important for students to know about that process?
Well, they are actually not supposed to get involved in something that is purely political. And in fact, this redistricting of states, there was a case that came before them about a particular state, and they decided that this should not be up to them. It's a political, it's a political subject, and it should be handled by the states and the people of the state, and not by them. So I think that they try to avoid something that is purely political. But so many of our issues have a political cast, it's rather hard to do that. They are careful.
And so, Jotwan, you've been teaching now for a couple of Supreme Court appointments. How do your students see that kind of moments? Like, how do they react? What are their thoughts? What do you do with those moments? They've come, relatively regularly for the past 4 years.
No, I would argue we're living in a great moment to teach these cases and to keep them relevant and in their context, because like you said, the frequency of them and the ability to students to access a lot of these cases, I think is real right now in this moment. So I try my best to utilize them as much as possible. The biggest thing is, though, I think, in my opinion, in working with young people, is keeping these cases relevant to the students themselves, but also illustrating that whole notion of how these case decisions affect the lives of real decisions, and that these are of real citizens, and these decisions are made by people based on majority vote, and everyone must agree. One of the techniques that I do like to try to give that personalization aspect to many of these cases is this notion of knowing the people, to where we really go into each of these participants' stories and we understand those stories quite well, so that no longer are we just reading names on a paper. We're talking about an individual, someone who has a heartbeat, someone who has a soul, a loved one. From there, then we're able to connect the case ultimately to a constitutional question. And Kirk, you mentioned this earlier, and I think this is a great time for me to plug it in from an educator's point of view. I love focusing on the dissenting opinions. Those dissenting opinions, I think, are something that kids can really put their teeth into, and they can really wrestle and ask ultimately tough questions of themselves and of their understanding of the Constitution, as well as the republic that we have underneath the Constitution. And so we really focus our attention on what is the court arguing, right? And so we come up with a list of those opinions from let's say I give them 4 cases. We'll take a list of those opinions from each of those 4 cases. We'll research those opinions, and then to continue to keep it real and relevant, we'll role play with groups about not only the majority opinion, but also the dissenting opinion.
Awesome.
Yeah, I think that's great, Jotwan. And it kind of connects to another, I think, question that I'm sure students bring up all the time. Maria on YouTube asked, Marbury went straight to the Supreme Court and he was told, hey, you're at the wrong court, go back to the district court. I guess, Dr. Malcolm, was that the case? And then also, how is it that most cases get in front of the Supreme Court?
Yes, that was the case. And that was one of the things that Marshall spent a lot of time on. The Supreme Court had very narrow original jurisdiction. There were only certain cases that dealt with counselors and diplomats and arguments between states that could go directly to the Supreme Court without going through the rest of the court system. All of the rest of the material or cases that the court took were on appeal. And so he makes this distinction that this is a case that should not be gone directly to them. It should have gone to a lower court first. And so they had made a mistake in bringing it directly to the Supreme Court. Could you just tell me the other part of your question, because I've forgotten?
Well, so no, I think that's great, and it's interesting, and it just makes me wonder. Today we hear all of these cases that come before the court.
It comes there, right?
Right, and the Supreme Court does have limited original jurisdiction. So I guess how do most cases arrive at the court?
And Dr. Malcolm has special knowledge of this because, Jotwan, next time you teach DC v. Heller,
on that case. Yeah, it's
absolutely.
The court gets thousands of requests to hear cases, and they only hear maybe 70 or 80 a year, and so, which is fewer than they used to. And so there are a lot of cases that might be very interesting, but they don't take them. So it's up to they have to have, you know, a certain number of judges who agree that they're going to take that particular case. And often they take a case where the lower courts have been at odds with each other. They've made decisions that are conflicting. And so it's up to the Supreme Court to decide what the rule ought to be. And so they tend to often to take a case like that where there's a disagreement among the lower courts so that they can kind of clarify an issue. But it can be very frustrating because you can have some very good cases. And there have been a lot of Second Amendment cases. There have been a lot of other cases that really ought to have been heard and weren't. And Justice Thomas and others have actually written dissents about the fact that those cases weren't heard. But I like your focus on the dissent because, as I say, I teach comparative law, and in civil law systems, all the judges agree. So far as you know, you do not get dissents. You just get the names of the judges and what their decision was. So it leaves out whether it's a close decision, what the arguments were, and you kind of miss out on the theories and meat of the whole thing if you don't get the dissenting arguments. And as said before, some of those go on to be really persuasive later on. So I think that the way we do it works well.
One of the most beautiful dissents I've read recently was, I think it was Trump, Hawaii v. Trump, or Trump v. Hawaii. The Sotomayor dissent in that was really, really beautifully written. If anybody wants to go take a look at it.
Of course, it does mean that students have to read a whole lot.
Yes.
That's always the challenge, right? Yeah. But we think, I personally think that's what makes it interesting, though. History isn't something that's inevitable. And the Supreme Court, I think, is the epitome of that, right? Decisions are made and they're handed down, and they are unanimous sometimes, but a lot of times it can be very close. And I think that is a part of that story, that there's always more than one side to history and how things unfold. And I think it's fun to dive into all of that. So
absolutely true on that one too, Kirk. Sorry to interrupt. The lesson, if you guys see me too looking off to my right off screen, my class is actually conducting a gallery walk activity right now where we are dealing with the very question that you brought up, Kirk. How can we have two different points of view on the same historical event? We're actually dealing with American progress, both from an American point of view and the Native American point of view.
Well, thank you.
But I do agree with you, Kirk. The aspect of history is not inevitable. So many kids just think that a decision is made and then this is the arc of history that's going to be shaped. And I try my best to debunk that myth in my class every single day. History is not inevitable. It is the study of choices. Humans make these choices, and these choices have the potential to shape the arc of our history in one direction or the other.
And sometimes the arguments are very close. You can see the logic of both sides. So it's, it's not surprising. As you say, it's a choice that's being made. And you might at some point reverse that choice, but at least you know what the arguments are. I think it's a great exercise to have the students do this role playing, because they need to learn, I think, to understand and be able to argue in a civil, polite way. But it's not a question of shouting. It's a question of, this was my point of view, that's your point of view, and to understand the different points of view. They're perfectly legitimate. But you need to be able to kind of take account of other people's viewpoints.
Yeah, and I think that's something that we try to do at the Bill of Rights Institute too, is to try to lay out or have lessons about cases that haven't been decided, to sort of pose the questions to students and let them be the ones to think about it, adjudicate it, and then when the ruling comes out, they're able to see, hey, did the justices agree or not agree? That could be an interesting activity to walk through as well. But I know we're coming down to our last few minutes here. So, Rachel, I don't know if you had any final parting questions.
I think I really love that we're ending on this note of that everything we do is a conversation. It's a conversation among our students. It's a conversation within our country. It's a conversation among the justices. No decision that's ever made is anything other than a choice. And I love that language, Jotwan, that we constantly make choices as individuals and collectively, and the justices are constantly making choices. And I think helping students and our educators help their students see the plurality of the choices that are laid out before actors at different points in history is an incredibly powerful way to support learning, because it also reflects back on the adolescents saying, well, I have choices to make every day, and I have choices about my own beliefs, and I have choices about how I'm going to behave, or decisions, major decisions that I'm going to take. And I think there's a really beautiful parallel there for many young people.
Absolutely.
It's a nice way to think of that. And a very sensible, kind of human attitude about the way these things happen.
Absolutely.
Thank you so much. We had a powerhouse crew on the phone tonight. So thank you to all of our viewers. Remember that you can keep sending us questions at Twitter at BR Institute, or on Facebook at Bill of Rights Institute. And next week, we will be live from the National Council for Social Studies annual conference in Austin, Texas. So if you subscribe to our YouTube channel, you will see a live webinar in our booth in Austin, Texas. So we're excited to see you there.
Absolutely. We hope you'll join us. And thank you again, Dr. Malcolm and Jotwan, for joining us today. We really appreciated the conversation. And we will see everyone later on.
Thanks a lot, guys. Had a lot of fun.
Enjoyed that.
Kirk, Rachel, good to see you. Dr. Malcolm, you should know you are a cult hero in my classroom. The kids were like,
oh, really?
Don't embarrass yourself with her.
Great. Thanks, everybody.
Take care.
Nice.
Bye, guys. Have a good day.